number 429 of 24,
Hmm.
you mentioned about liberty to file an appropriate application. I have
Yes.
already filed this application. I am just mentioning this. I have also served the copies to the person, just all the respondents.
Please give the number. We will list the application.
ठीक है, sir.
I am mentioning item number 57 of today's list.
Yes.
57 of today's list
Ah.
for upgradation, especially for the regions. My client is 77 years old. This
Yes.
is a matter regarding freedom fighters pension to the daughter of the deceased freedom fighter. I mentioned this matter before your lordship's earlier occasion when my lord's pleasure was to upgrade. Now it will not be taken.
So
Milord, I
today,
have noticed the other side. Have it, Milord, upgraded to some extent?
no. Item 11, 12, and 13 also pertain to freedom fighter pension for widowed daughter.
No, it is not widow daughter. It is Milord daughter, unmarried daughter.
Okay.
57 is
All
unmarried
right.
daughter.
57, please upgrade next week.
All right. Well, I am
Yes.
giving.
My lord, may I permit it to one matter? My lord, it's a medical issue, your lordship. The two panchayat area, only one primary health center is there, and there is no basic. The people, 1 lakh people are not getting basic.
You
medical.
give the number. It's a fresh case.
I'm for the here your lordship earlier occasion directed to respondent to file a status report of the present condition, and from the matter is appearing from 2023, your lordship.
You
July.
give the number. Let us see within the next 2 weeks.
Fixing the matter, your lordship. Very urgent issue, yes,
All
lordship.
right. All right. You please give the number.
Madam, may I leave to mention regard to with issue that auxiliary nurse for the male, those who are not getting the chance since 2018, and my lord was already interfered with, and opposition direction was given, and reply also been submitted on our part. It has been exchanged. So my lord would be kind enough to take up this matter, so that my lord.
It's a hearing matter.
My lord, it's a hearing matter.
Next 2 weeks we will try to do so. Yes.
My lords, may I kindly be permitted to mention, my lords, for upgradation, my lords, item number 91 and 92 of today's original side cause list, my lords. My lords, I am incurring demurrage charges on a daily basis, my lords, in excess of rupees 3 lakhs per day. I had filed this application in July 2024, my lords. So the demurrage is getting piled up, my lords. If my lords may kindly take it up, my lords.
This Friday, there's no court.
Friday is a holiday, my lord.
Friday is a holiday. Probably next week, you please upgrade it.
My lords, much obliged, my lords.
My lord, I want to mention regarding for leave matter for item number 33. This matter, the contempt case is lying before Justice Sobhasachi Bhattacharya. 2 times it was adjourned because the appeal is pending over there. Again, it is going to come up before the learned court on 22nd November. So kindly give us a leave. Today it is item number is 33.
You please give the letter. Today we can't take it up. You give the letter, we'll try to do something.
Your Lordship, may I be permitted to mention the matter? Your Lordship, may I be permitted to mention 2 matters, MAT 1985 and 1986 of 2024 for inclusion in the daily list.
Yes. Fresh matter inclusion.
Your Lordship, may I be permitted to mention one appeal, my lord, which has been wrongly filed before your Lordship, my lord. It's a group 2 appeal, my lord.
Okay, please give.
Please, my lord.
We'll send it to the appropriate bench. Yes, please call.
My lord, I am petitioner myself, Sandipon Khan. My PIL is pending since 2015 over restoration of a municipal park in the suburban town of Rishra. So, unfortunately, my learned AOR, Soumitra Mukherjee, has passed away. So, it is a small matter if my lord...
yes, you give the number. We list it within the next 2 weeks.
My lord, may I be permitted to mention this matter, my lord? This pertains to MAT 1281 of 2023, my lord. Herein, the son of the petitioner was illegally picked up, and then an NDPS case was charged against him. Subsequently, orders were passed to compensate the petitioner, but wherein only 15,000 were awarded to the petitioner. But, my lord, what we need is we need the erring police officers to be punished in this matter. For this,
now, is the matter running in the list or
yes, my lord. The matter is running in the list, but my lord, I am praying for an upgradation. If this matter could be taken up on any day, my lord.
You please give. Let us check up the file. Then we'll try to do something.
Deeply obliged, my lord.
Yes, please call.
To be mentioned, item number 1. Matter, I am for the petitioner, my lord.
Respondent, have you served the respondent?
I have served Mr. Abhitesh Banerjee and Ipsita Banerjee on behalf of the state. I have served the notice on Friday, my lord.
No, sir, one thing.
My
The
lord.
correction can be done. In the first paragraph, you said that not taking action, that not is missing, that can be done. But you are making an allegation that the private respondents have come to the petitioner's house, they are threatening, demanding 6,000 rupees, etc.
Yes.
But
Yes,
unless you,
not only that, private respondent did not allow the petitioner to collect their flowers from their flower garden. And when they went there, they have threatened and taken away. And
correct,
also,
sir. No. This is a disposed of matter.
yes,
Now there is a fresh cause of action. Now, if you say that the superintendent of police is not taking action, you file a contempt petition.
My lord, it is a appeal matter, my lord. Due to threaten, they are not.
All right, then you have to file an application, bring the new facts on record. Without bringing the facts on record, how to issue notice?
I have the record 4-time communication to the SP after your
You
lordship.
file an affidavit. You file an application to bring additional facts and seeking for further direction.
My lord, today the typological mistakes should be corrected. Then and tomorrow that will be passed. I shall show before your lordship all the documents.
Typographical mistake was only in paragraph 1.
And also the paragraph 3. Paragraph 1 are not taking action, and paragraph 3 is your lordship observation, the last of which date application date 15/2/2012. But your lordship come to page 23. Last application is 22nd August 2024. Page 23.
It should be 22nd August 2024.
Yes, and also first paragraph not.
Yes.
Not.
Yes, please take down. The matter has been listed under the caption to be mentioned. It is pointed out by the learned advocate for the petitioner that there are 2 typographical mistakes in the order dated 12/9/2024. In full stop. In paragraph 1, after the word authorities are, the word not, NOT, inverted comma, should be added. In paragraph 3, the date should be mentioned as 22/8/2024 instead of 15/2/2024. These corrections shall be effected in the order dated 12/9/2024, and this order shall form part of the order dated 12/9/2024. Para. The learned advocate for the petitioner submitted that though direction was issued in the writ petition, till date the superintendent of police has not taken any worthwhile action, and the petitioners are facing severe threat from the private respondents. These being subsequent events, we grant liberty to the petitioners to file a fresh application duly supported with an affidavit, bringing all facts on record, and move the said application after serving copies of the same on the learned government council.
My lord, I shall file the affidavit of service indicating that all communication, 4-time communication, that affidavit.
File an application. The matter has been disposed of. Unless you file an application, nothing can be done. Please. Next.
My lord, my lord, item number 2. My lord, the question which has to be decided in this petition is that.
Mr. Chatterjee, one preliminary question.
My lord.
The election notification has already been issued.
My lord.
And nominations have been called for.
My lord.
Nominations have been filed. Now, by way of this PIL, you say this particular candidate, the 13th respondent, is not a scheduled caste candidate. She has filed a nomination mentioning her father's name, not her husband's name. These are whether a writ court can go into all these things.
My lord, I am only seeking a direction upon the Election Commission of India to consider my representation. I know the constraint of the writ court to entertain the petition other than in the form of the election petition. However, Lordship, the first question, the Supreme Court in its decision in 2015, that was in Krishnamurthy versus Shiv Kumar, has distinguished between two categories. One are the offences which are termed under the Representation of People's Act as fatal for the election. Means, Lordship, the offence which are enumerated under section 100 of the Representation of People's Act. If those offences are attracted, the election will be fatal. But there are certain offences apart from that. Even the offence, particularly specifically alleged here, that is, Lordship, non-disclosure or suppression of the material informations in the nomination papers, that is given under section 125(1) of the Representation of People's Act. Lordship, kindly come to section 125(1).
No. On what date did you give the representation? On 2nd of November 2024.
Yes, my lord.
The petitioner has sent an email.
Yes,
and,
after. My lord, I am appearing for Election Commission India, my lord. My lord, I beg to state, once the press notification has been given, my lord, the only remedy is the election petition, my lord. There is no other remedy.
Well, Lord, I appear for the candidate, Lord, who has filed her nomination. 13th is the by-election. That is day after tomorrow. Lord, at this belated stage, Lord, kindly do not, Lord, and my marital status can't be, Lord, a subject matter either before the Election Commission or before the public interest litigation. It's a private status.
No. Regarding the communal status also they are questioning.
Yes, that has been verified by the Election Commission, Lord. In fact, one of the candidates has already filed a writ petition in the circuit bench. That is appearing in the list today.
Item number 12.
And not as item number 12, when the Election Commission has been asked to submit a report there.
The returning officer.
Lordship, only one thing, Lordship, I'm asking.
The same issue, my lord, same issue.
And my lord,
he has
also said it's a
corrupt
practice under the Representative of People's Act. Lordship, may I only
now, who filed the other writ petition before the circuit bench?
One of the contesting candidates.
Oh, then the aggrieved party is already there.
No, even I am also aggrieved being a voter.
No.
Lordship, being a voter.
Sorry,
Lordship, may I only apprise your Lordship two things, Lordship. One,
you can do one thing. You can withdraw your writ petition and pursue your matter before the Election Commission if you
same period of there, my lord.
No,
Same
Lordship, I only I'm seeking.
Same ST certificate, my lord.
This can be disposed of by this Honorable High Court.
Yes, we have heard you, sir. We have
Lordship,
heard
kindly dispose of the petition.
By this writ petition, the petitioner challenges the nomination filed by the 13th respondent, stating that there has been suppression of fact and that the 13th respondent does not belong to a scheduled caste community. Admittedly, the election notification has been issued, nominations being called for, nominations were filed, they were scrutinized, and the list of valid nominations have been published. The by-election is scheduled to be conducted on 13/11/2024. At this juncture, the writ petitioner, claiming to be a public interest litigant, sent an email on Saturday, the 2nd November 2024, to the Election Commission of India, and stating that the nomination paper of the 13th respondent should be cancelled. And on 5/11/2024, the writ petition has been filed. It is settled legal position that once the election process has begun, the question of interdicting the election process, that too by way of a writ petition filed under Article 226 and also by way of a public interest litigation cannot be entertained. If at all a person is aggrieved by the candidature of, the validity of the nomination of any candidate who offers himself or herself for the elections, the only remedy is by way of election petition. No doubt, it is true that courts have carved out certain exceptions, but those exceptions were in respect of cases where the monstrosity of the situation called for an extraordinary relief. In the instant case, we find no such situation arising for consideration for the court to issue any direction in this public interest writ petition. Hence, writ petition dismissed.
Lordship, only one thing, one indulgence, Lordship, may I seek? Instead of dismissing it, Lordship, kindly remand it before the election commission. I have, being a citizen, let me pursue my...
No, you know the law better.
Lordship, this dismissal itself will not... Kindly, Lordship, kindly apprise one situation, Lordship. May I only one indulgence, Lordship? 1 minute, Lordship, 1 minute. May I be heard for 1 minute? Lordship, one thing. There is a distinction, certain offences, which leads for cancellation of the election. I am not asking for that. I am asking persuasion of the appropriate proceeding by the election commission against a person if it is proved there are the discrepancy in the affidavit.
They have the same period in the writ also, my lord. Same period in the writ
does
also.
not lead to
The writ is parallel going over there right now.
Sir, a minute, sir. Section 125 is not fatal for the election. Election petition, Lordship, there is a definition of the election petition and election petition where the election is challenged. Kindly see
You can file an appeal against this, our order. We will
Lordship,
upload
kindly.
it. Sir, Mr. Chatterjee, your friend standing to your right also wants to move a similar writ petition, so that it will be the same fate. So don't move.
The only thing that instead of dismissing, Lordship, let me test my fate with the Election Commission of India.
Thank you. Next.
Item number 3 to 5.
My lord, I mentioned one matter.
That also will be dismissed. Don't move. Don't exhaust. Don't exhaust. You please advise your client. Next, item 3 to 5. Sir, this is a hearing matter.
Yes, this is a hearing matter.
Mr. Mitros has to make reply submission. No, has already done. Where is the Advocate General?
Advocate General. The Advocate General is now coming to court regularly, and I'm sure it will be coming if he wants to. I am to give a reply to the argument and conclude the hearing.
Sir, one small recap, if it is possible, because the last time we heard the matter was on 8th of July.
Yes.
Correct?
Yes, my lord had 8th
July, yes. Then matter has remained.
It's
Advocate General's illness. He was not coming to court on that ground. Now that he is coming to court regularly.
Yeah, what we'll do is we'll take it by way of a physical hearing next week, so that Mr. Advocate General will also be informed. Mr. Dey will inform the learned Advocate General.
His state is represented.
I will.
Immediately after admission, we list it. So that one small recap you can give.
Beg your pardon, my lord.
A small recap.
Small recap.
Yes, I can do it today if my lord so pleases.
Not today. We'll have it next week.
Our urgency is this, Mr. Taylor Lordship.
Fifth matter was being heard.
There is no urgency, sir. There is no urgency in an
urgency is this. There is urgency this, Miller. We've got a stock of liquor in the shop. Now they have all got expiry dates.
No. The older they get, better.
No, they have all expiry dates. It's not wine. Spirits, they have got expiry dates. Anyway, that's similar. Well, kindly, matter is pending, because of government taking adjournment, matter has been delayed.
Fifth matter was being heard, my lord, if I remember
Or
correctly.
we can do one thing. Today we can pass an order.
Very good. Then as soon as possible, Lord.
No, 1 second, sir. We can permit the petitioners to surrender the stock. You can surrender the stock, and then we will hear the writ petition.
That will delay further. Can we hear it out? Let's come to the end of the hearing. Can we keep it as
the matter? Mr. Pathak, you give a date next week, immediately after admission.
Next week, can you make it peremptory? If Advocate General chooses not to come, it is his decision.
Not choosing, he was ill.
He will come, sir. Definitely he will come. Next week.
Next week. When, the next Monday?
Just the court officer will check the diary.
To be mentioned next Monday, my lord?
Immediately after admission.
After admission.
Okay. Next Monday.
Yes.
Item number 6.
I appear for the appellant, my lord.
Electricity connection.
My lord.
Last week, have you served respondents?
Yes, service has been done, but I have got an instruction that in respect of another writ application, in respect of the self-same cause of action, this is relating to granting of electric connection.
Yes.
One matter was released by your lordships, and that has been sent before Honorable Justice Harish Tandon. The number is.
Oh, yes.
Yes.
Because Justice Bhattacharya cannot hear this matter.
Yes. Since one of us, bracketed my name, is not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the papers be placed before the Honorable Chief Justice for necessary orders.
For admission, item number 7.
Lordship, I appear for the appellant in this matter, Your Lordship. Your Lordship, we were to cure certain defects. It's not happened, Your Lordship, owing to a bereavement, a sudden bereavement in the family of the advocate on record, Your Lordship. We are seeking a very short date, Your Lordship.
All right.
Lord, I appear for the respondent in this matter.
Yes, Mr. Bose. The time for rectifying the defects pointed out by the additional stamp reporter is extended by 2 weeks from date. List the matter after 2 weeks.
I'm so grateful to Your Lordship.
Yes,
Deeply
ma'am.
obliged.
Item number 8.
Number 8, I am for the petitioner respondent, my lord.
I am for the appellant, my lord.
Virtually korbe.
We have this hearing matter, sir.
Yes, my lord, there is a stay, my lord. Your Lordship heard this matter. This is in connection with the positive variation of the oil, which was found.
We remember. Next Wednesday.
Lordship.
List next Wednesday.
Item number 9.
For 9, my lord, there is a section 5 application, my lord. The appellant, my lord, met with an accident, my lord. My lord, that is the reason, my lord, she is unable to come from Malda. My lord, kindly gives me 2 weeks time, or my lord, 10 days time, my lord, she will come, my lord.
Okay. At the request of the learned advocate for the appellant, list the matter after 3 weeks. You give a date after 3 weeks.
My lord.
All right,
obliged, my lord.
Item number 10.
This is that.
My lord, 10 I am for the writ petition respondent. I'm for the writ petition respondent.
And who will appear for the state?
So, Mr. Shopman is appearing on behalf of the state. I'm paying for note today, Lordship.
Then let it be not this week.
All right. Give a date after 2 weeks at the request of the learned counsel for the appellant. Sir, the video, the courtroom video is not visible.
Courtroom video.
Yes. Now the other camera is visible. Okay. Next.
Item number 11 to item number 13.
This matter, madam.
In 13, I am for the petitioner respondent. In 12, I am for the respondent writ petitioner.
This is that widow daughter.
My lord, your lordship kindly
Widow daughter.
over, my lord. Learned additional solicitor general will come and argument. He has requested me to pay for a short passover.
Not today.
Not
Next.
On behalf of
not today. Item number 14.
I am for the respondent.
This is they quashed the FIR on the ground that the bank matter has got settled. That is the issue. Who will appear for the writ petitioner?
No, I am for the respondent.
Respondent bank. Have you been served?
Yes, my lord. Yes, my lord. I have been served.
None appears for the appellant. Mr. So-and-so appears for the respondent bank. Adjourned by 3 weeks. Next.
Item number 15.
This was my appeal.
Banerjee, we'll take it up next Wednesday.
My lords, I appear for the private respondent.
Lordship, I'm for the state, Lordship.
All right. Convenience set has been served on everybody?
Yes, my lord. Yes.
All right.
My lord, now, my lord, the private respondent has appeared. My lord, I'll supply him, my lord, a copy of the
I have received the copies.
My lord, he has already.
I have received the copy. I have
The convenience set has been filed and copies have been served on the state, the respondent state, as well as the private respondent. List next Wednesday.
So grateful to you.
Grateful, my lords.
Grateful, Lordship.
Item number 16.
Lordship, may I permit to release one matter from your Lordship's list, item number 41 of today's daily list, Your Lordship.
To wait for 5-10 minutes. After 29, you mention.
Lordship, on behalf of
Ah.
appearing on behalf of the respondent number 1 and 2 in item 16.
And ASG was appearing for the appellant. The appeal has to be heard, Mr. Banerjee.
Yes, my lord.
Appeal has to be heard.
Your lordships had granted an injunction where I said I had opposed the prayer for adjournment on the last occasion. Your lordship had kept it after the vacation, and it will not.
Today I am praying for adjournment.
Oh, no, that's all right, my lord. We can we can come back on any other day.
No, it will come next Wednesday.
Very well. Very well.
There is some very urgent matter today.
No, my lord, absolutely. We'll come back on that.
I am sitting here.
Yes, my lord. Come back on that.
Your lordship, one small indulgence, your lordship, item number 14, your lordship. I was appearing for the petitioner, your lordship.
We adjourned it, nothing. We have not done any damage.
Adjourned it to, yes, your lordship.
We will give the date, court officer will give.
Yes.
Yes, your lordship.
This item number Muslim marriage registrar.
Item number 17. There is a direction for filing an affidavit.
My
They
lordship.
are yet to file an affidavit.
My lordship, Mr. Galib is appearing in this matter, my lordship, for the state, my lordship. He is not well. He is not in the court, my lordship, today. I am
No,
paying.
that is correct, madam. Have you got this? We directed the production of the original file, and an affidavit should be filed by the appropriate authority, clearly setting out all facts regarding the existence of the vacancy on the set date, when the particular post, either permanent or temporary, was created, and orders supporting. Where is that affidavit?
My lordship, I don't have that instruction because he's not well, my lordship. I
All right,
don't have
doesn't
any
matter.
file.
Whether any of your department officers are here in the court?
I
No.
don't think so, my lordship. I'm not the junior in this matter, my lordship. He is suffering from a high fever, my lordship. I'm paying this for just week accommodation, my lordship.
Because of change of weather, everybody is suffering. Tamal Taru Panda, he also appeared for state. No, you can do one thing. You can inform the concerned junior who is appearing along with Mr. Galib that if the affidavit is ready, please serve copy on Mr. Shami Mohammed today,
My lordship.
so that we'll save on time.
My lordship.
We have heard Mr. Shami Mohammed, learned advocate for the appellant, as well as the learned advocate appearing for the state, and the advocates for the 8th respondent. It is submitted that the learned advocate appearing for the state is unable to attend court today, and adjournment is sought for. Full stop. In terms of the order dated 23/9/2024, the appropriate authority was directed to produce the original file and also file an affidavit. Let such affidavit be filed not later than 18th November 2024. List the matter on 20th November 2024.
My lordship, kindly a week accommodation, my lordship. Next way,
Oh, next week you can't do it, huh?
because my lordship, if the affidavit is not ready, my lordship,
All
my
right.
lordship has to
File
finalize it, my lordship.
the affidavit by 22nd November. List the matter on 25th November.
My lordship.
Okay.
Great. Item number 18
and 19.
I appear for the respondent, my lord.
My lord, I am
19,
for the appellants in item 19, my lord.
I'm led by Dr. Mullidhar, Learned Senior Counsel. My lords will recollect this is the Port Trust eviction matter, your lordship, where slum dwellers have been evicted without following the due process of law. And in our CAN application, if my lords take CAN 2, we specifically sought for in prayer C, my lord, rehabilitation. State has been given opportunity
to file affidavit.
Today. However, no affidavit in opposition has been filed by the state till date, your lordship.
Mr. Banerjee.
No, we have filed our affidavit.
Lords, it was a report.
No, in the CAN application, where eviction has now taken place. Now, what they claim
may I
is,
say this?
yes,
Because this land belonged to Calcutta Port Trust.
Yes.
We have, this court directed the police to ensure that the order of the Calcutta Port Trust for eviction be carried out. On the basis thereof, we rendered the necessary police assistance and they've been removed. This is the present situation. It's not that we carried out any eviction proceeding or anything like that.
Now, CAN 2 of 2024, which respondent was direction is sought for compensation? Against which respondent?
Against both the respondents, your lordship.
No, the eviction drive is not by me, it's by the Calcutta Port Trust.
Wait. 1 second.
CAN 2, I had the understanding it is against the state. How can a port rehabilitate?
My lords, may I say this, my lord?
No. 1 second, sir. 1 second. CAN 2 of 2024 is
prayer CS at page 18, your lordship.
CAN 2 is
no, CAN 2 is something else. It is grant.
This is my sincere apologies, my lord.
Can prefer an appeal.
CAN 1, your lordship, and my sincere apologies, your lordship.
CAN 1, 1 second.
CAN 1, page 18, prayer C, your lordship. Okay.
CAN 1 in MAT, which in this in MAT 13 or 2?
13 or 2. That's right, your lordship.
CAN 1.
CAN 1.
Education তুমি ওখানে জানি কি করছো?
কেন বলিস না? ফিজিক্যালি মামলা চলা হবে।
CAN 2, and your first is?
May I pray one thing, my lord? Actually, this matter cannot be done.
No, it can't be. We are trying to find out who has to file the affidavit.
My lord, on the basis of the order itself, I can demonstrate this is a rare example of bulldozing justice. Thus now is going on. Court itself found that you are unauthorized occupant, but does not take recourse to Public Premises and Unauthorized Occupant Act. There has a handle of law. Not done, court without implicating me at party, evicted.
Now, prayer C, as your junior has pointed out, is for a direction to the respondent authorities to provide for rehabilitation, resettlement, monetary compensation. And who are the respondents? Let us see the cross title. The state.
Respondent state, none. My learned advocate of record, my lord, went to intervene in this matter. He was refused.
Now, have you not? That Shyama Prasad Mukherjee Port Trust is also a respondent, first respondent.
Yes, I am the respondent, my lord.
That's right, my lord. Shyama Prasad, respondent number 1, my lord. I'm in item 19. It's a connected matter. In my matter, your lordship, the Port Trust has filed an affidavit in opposition. However, an affidavit in opposition from the state is awaiting your lordship.
Or Mr. Banerjee, you can also file a affidavit stating that.
I am told me the affidavit 19 item number 18 is my. I do not know why my learned friend has started addressing your lordship.
This is item 18, item 19 connected.
No, please let us have item number 18. Let my learned Mr. Basu is here for item number 18. You intervene.
I am in item 19. It's connected matter. So
all right. Now item 18 affidavits have been filed.
Let my lord resume, my lord, physically, then we'll do it.
Item number 18 is, my lord, what is taken up?
My lord, resume karo.
You confused the entire matter over here. Now,
List next week.
Mr. Basu is there. Let him do that. You've jumped at item number
No,
9.
Mr. Banerjee, one thing. If you have not filed an affidavit in item 19,
I will do so. I
you
will
please
check up
do
with
so this week, so that next week when we take it up, at least the proceedings will be complete. You
Well,
can raise
I'll do that.
whatever
I'll
defense,
do that. I'll do
saying that you are not responsible for resettlement. It is not your authority. You can always take any
Yeah,
stand you want. Yes, sir. Thank you.
Item number 18.
Your Lordship, Dr. Muralidhar Leonard Senior Counsel was only requesting if this matter instead of next week can be kept in the first week of December, Your Lordship.
No. My lord, I want before that. Let 18
No.
may be taken up. 18 may be taken up. Kindly segregate the 19.
All right. Item 18, this order. Item 19, liberty is granted to the respondents to file their affidavit in opposition. Let the matter be listed on first week you want?
4th of December in Wednesday, Your Lordship.
4th of December.
I'm grateful, Your Lordship.
12
Grateful. Good. Item number 20, main file not here.
What happened to the main file?
We have sent several requisitions, but since the department is reallocating, it is shifting to some other building, that's why they are not in a position to send the file right now. Hopefully, within coming.
We will request the learned advocate for the petitioner to bear with us for a week.
All right.
The issue is, my lord, during the pendency of the appeal, my lord, at the instance of the police, my shops have been demolished.
We will take note of that because now they are shifting to a different premises. There's some confusion, sir. Because space constraint is there now in our.
Because, my lord, we informed the district magistrate SDO did nothing. The local police station, the local OC, my lord, at his own instance, demolished the entire.
No, my lord, I have a
shops.
different report. So far as the police is concerned, I have a different report.
We will somehow trace your file and get it by 2 weeks. Please.
2 weeks.
2 weeks.
Yes.
2 weeks.
Next.
Item number 21.
Item number 21, my lord, I appear for the appellant, my lord. I'll be seeking some time, my lord, because the appellant is a senior citizen, my lord, under hospitalization in Delhi. He's still under oxygen support, my lord. His son will be coming to affirm the petition, my lord. So we'll require, my lord, about 2 weeks time, my lord, because he needs to be explained, my lord, the entire thing. So if it may kindly.
At the request of the learned advocate for the appellant, time for filing the stay application is extended by 3 weeks from date. Let the matter be listed after the stay application is filed.
Grateful, my lord.
Item number 22.
Service complete, sir?
I'm for the appellant. I'm paying for not today.
No. Last occasion, we directed you to complete service.
I have served to the opposite party, my lord. Matter come up for hearing on 12. That is why my.
Okay.
Paying for not today.
All right, not today.
Item number 23.
My lord, I appear for the appellant in this matter, your lordship. My lord, there has been a bona fide mistake on the part of the learned advocate on record, my lord. He has not added the chief judicial magistrate as a party. Although, my lord, I have served upon the learned advocate of the state who has appeared in the, my lord, before these learned single bench. Lordship, hereby, I am challenging the order dated 26/9/2024. My lord, the court was prima facie satisfied and has granted an interim protection. But the matter of fact remains is that, my lord, the order that we have challenged, the order of the learned chief judicial magistrate had not yet been served upon us, and that is why we are not being able to avail the remedy before the DRT. And, my lord, our presumption is that there has been a suppression before the.
All right, one second. We will direct the concerned court. Which is that CJM court? Which place?
That should be Chief Judicial Magistrate Barashat, not 24 Parganas, Barashat.
Have you filed a copy application?
Lordship?
Have you filed an application for supply of the order?
No, your lordship, because the matter has been disposed of from there, and we have just been served a notice by the police authority to vacate the premises. We were not a party before the CJM, your lordship.
That is true. You can file a third-party application. We will grant you leave.
Lordship?
We will grant you leave to file a third-party application before the Court of Learned Chief Judicial Magistrate Barasat not 24,
Lordship.
and the application shall be, we will direct the application to be entertained and a certified copy of the order be furnished to you. Thereafter, you avail that remedy.
Lordship, till then, your Lordship, then an interim protection be granted. Otherwise, Malad, they will proceed towards the sale of my property. Malad, I am not being able to avail my right. I have filed a Section 17 application before the DRT by challenging the possession notice. Malad, they have not served upon me, Malad, the order of the Chief Judicial Magistrate. Hence, Malad, I am not being able to challenge. Malad, the liberty, Malad, that I have got, Malad, I am not being able to avail the remedy, your Lordship.
Lordship, interim protection might not be given, Lordship. Either way, Lordship, the
What interim protection you want, sir?
May I just may I paid for
Section
this thing,
17 was filed in 2023, Lordship.
This is absolutely a misuse of the sufficiency action, Malad. Malad, kindly consider, Malad, by issuing my advocate notice, Malad, they have dispossessed me. My Section 17 application is pending for adjudication before the DRT.
That is correct. 17 is pending. Every step taken under the Surface Act is a measure. You can file a miscellaneous application, or a separate appeal under 17 is maintainable against 14 action.
Well, I'm grateful to Lordship, Malad. In this case, we have not get any opportunity to file the same, Malad.
No, that is what your colleague, Madam Roy Chaudhary, she said that she does not, your client does not have a copy of the order passed under Section 14.
Yes.
We will direct you to file an application, third-party application before the court of CJM, and within 3 days from the date of filing the application, they will give you a certified copy. You file a miscellaneous application before the tribunal in the Section 17 matter, pray for appropriate.
Till then, Malad, no courtship stick may not be taken by the financial institution, Malad. Kindly, Malad, protect me in this extent, Malad.
No, absolutely.
This infra-court appeal has been filed by the writ petitioner, being aggrieved by the order dated 26/9/2024 in WPA 24041 of 2024. We have heard the learned advocates for the parties. The appellant submitted before the learned writ court that an order has been obtained from the learned Chief Judicial Magistrate Barasat, not 24 Parganas, without mentioning that an application under Section 17 of the Surface Act has been filed by the appellant writ petitioner before the Debt Recovery Tribunal, Roman 3, Calcutta. The learned single bench disposed of the writ petition by granting liberty to the appellant writ petitioner to approach the Debt Recovery Tribunal within a period of 2 weeks from the said date, until such time further measures shall not be taken by the finance company with regard to the property in question. The contention raised before us is that the appellant, namely the borrower, was not a party to the application filed under Section 14 before the learned Chief Judicial Magistrate, Barasa, and therefore they are unable to obtain the copy of the order till date. The appellant writ petitioner could have filed a third-party application before the learned Chief Judicial Magistrate requesting for a certified copy of the order passed under Section 14 of the Act. However, that procedure appears to have not been adopted. Full stop. Thus, taking note of the facts, and we direct the appellant writ petitioner to file an application before the learned Chief Judicial Magistrate for issuing certified copy of the order passed by the said court under Section 14 of the Surface Act, which was at the instance of the respondents 3 and 4, is it? 3 and 4. Respondents 2 and 3 herein. 2 and 3 herein, namely IIFL Home Finance Limited. And if such application is filed, the learned chief, the court of the learned, the registry, the court of the learned Chief Judicial Magistrate Barasat, not 24 Parganas, shall supply a certified copy of the order passed under Section 14 within 3 days from the date on which such application is filed, provided the application is complete in all respects and the requisite fee is also has also been remitted. Full stop. The appellant had the benefit of an interim protection for a period of 2 weeks. Since we have issued the above direction, the interim protection granted in favor of the appellant writ petitioner shall be in force till 20th November 2024 and not beyond the said date.
I'm grateful. I'm grateful.
Next.
Item number 24.
But I am for the appellant, my lord. My lord, I have challenged the order of the Honorable Justice Bhattacharya, my lord. May it be released, my lord.
Okay. Since this appeal has been filed, challenging the order passed by one of us, within bracket, Honorable Justice Hiranmaya Bhattacharya, the appeal is released from the list of this court, and papers be placed before the Chief Justice for appropriate orders. Next.
Item number 25.
My lord, I appear for the appellant.
But
Yes, sir.
I am appealing for the respondent, my lord.
Very good.
But I am taking a point of maintainability of the appeal. Appeal has been passed in exercise of contempt jurisdiction, and it is only a rule has been issued. So, my lord, under section 19, the appeal cannot be maintained. It is only an appeal against order of punishment, which is appealable under section 19.
Mr. Sen, I think this is a clause 15 appeal.
Yes, your lordship,
Yes,
we are fully covered by your lordship's own judgment.
Even in a clause 15 appeal, my learned friend has to show that the impugned order qualifies as a judgment.
Yes.
Within the meaning of clause 15.
Exactly.
Kindly have a look at the order what has been passed.
My lord, in the while learned judge, no, my lord, there are several points. My learned friend will take the question of maintainability after we shall submit before your lordship.
Very well. Very well.
Yes.
Let my
Now,
learned friend.
this is a case where, my lord, the procurement of steel was concerned in terms of the CPWD's guidelines and the manual. Now, the learned single judge struck down Rule 27(2) of the CPWD's manual, and against that we preferred an appeal. Now, your lordships had been pleased to modify that order, quashing 27(2) and gave direction to us to issue fresh order in terms of the steel ministry notification. Now, that is the thing, the main matter. Now, the question, my lord, I shall be urging at least 7 points whether the learned judge had any jurisdiction to pass such an order. I have never heard in my 47 years practice that, my lord, the learned judge, while issuing a rule of contempt, delivered a 15-page judgment. 15-page judgment. And before that, under the appellate side rules, the rules framed by your lordship's court under 71 Contempt of Courts Act, the provision is once a contempt petition is filed, if a prima facie case is found, then the learned judge may either issue a rule or may pass any other order. That is Rule 19. Now, the learned judge dispensed with issuing some rules on 2 occasions and wanted us to file the affidavit of compliance. Now, the affidavit of compliance was filed twice. The first affidavit of compliance clearly discloses that there was sufficient compliance of the direction passed by your lordships in division bench. Now, the first moot question is, when the order has been passed by the learned single judge, has been modified by your lordships, whether contempt lies before the learned single judge, number 1. Number 2 is that when the contempt application was filed, the appeal was pending before your lordships. But in terms of your lordship judgment and modifying the order, the contempt application stood infructuous. I took the point before the learned single judge because there was no application for amendment of the contempt application, either in terms of your lordship judgment or otherwise. Therefore, the learned judge lost the jurisdiction to proceed with the contempt application. Even if that point was raised, the question of doctrine of merger. Now, doctrine of merger, Supreme Court has said that the appellate court judgment that shall be the main issue for execution or compliance of the judgment. Now, the number 1 point, the learned judge committed a grave error of jurisdiction by suo motu taking cognizance and without, my lord, leaving it to your lordship to decide such issue of modification of the order passed by your lordship. Therefore, contempt does not lie before the learned single judge, number 1. Number 2 is, even if a contempt application is filed and the learned judge on the first day issues notice to the alleged contemptor, he has, it shall be deemed, applied his mind in terms of Rule 19 of the Contempt of Court rules framed by the 1971 Act. There is no scope for issue a further rule at the last stage, and by delivering a 15-page judgment, which he has decided the contempt itself, number 1. 15-page judgment, all decisions cited before the learned single judge of the Supreme Court as regards the maintainability of the contempt application, whether a liability of the contempt. Secondly, my lords are aware, if there is part compliance, there is no contempt. If there are 2 interpretations, there is no contempt. Now, the learned judge, how did he assume the jurisdiction to decide the contempt itself by delivering 15 pages judgment, and then thereafter he issued a rule. After, my lord, we filed 2 compliance report before the learned judge showing that we have done this. Now, if this action of our part is wrong, but in compliance with thereof, my lord, a fresh cause of action arises, a fresh writ petition. Therefore, my lord, we are the preliminary point my learned friend has taken about the maintainability of the appeal, your lordship judgment. I am placing, my lord, I had the privilege to argue, my lord, before your lordships, that here your lordships have been clearly pleased to hold by referring to some Supreme Court judgment and other judgments that latest patent appeal under clause 15 shall lie. And this appeal is not under a criminal miscellaneous jurisdiction arising out of section 19 of the Contempt of Courts Act, but is a mandamus appeal, a latest patent appeal.
Sorry for interruption, sir. Sorry for interruption. One small clarification. Now, the direction issued by the division bench was slightly modifying the direction issued by the learned single bench, yes, and by directing amendment to be carried out.
Exactly.
And you have filed 2 compliance report.
Yes.
How has the judge commented upon that compliance report?
That is page 147, the details of the stay application. That is, we have given the details at 147. Volume 2. May not kindly come to page 147. This is of 14th August 2024. The detailed guideline about the notifications and decisions have been taken. My lord, if on a contempt application, this is not to be argued before your lordships, that on perusal of a direction of the Honorable Court, if we rightly or wrongly take a decision for compliance, and my lord, there whether contempt lies or there is a fresh cause of action, number 1. Number 2 is the consistent view of the Supreme Court down the line from Dulal Chandra Bhar's case of Calcutta Court, followed by the Supreme Court of 1955 Calcutta and 56 Calcutta, is in rarest of rare cases, rule of contempt shall be issued. There shall be an attempt to execute the order, because contempt is not only for punishment, it is for execution and consequential relief. Number 2. Number 3 is that your lordship kindly comes to page 147, which I have referred to. There, my lord, your lordship will kindly find the details of para 27.2 of Works Manual, and the detailed reason has been given. Now, if this is a wrong decision taken at all by the authority which is the appellant before your lordship, whether contempt lies or whether a fresh cause of action. Second point is the basic, I shall be placing a Supreme Court judgment that when there is the order of the learned single judge is modified, the contempt lies before the division bench. The doctrine of merger lies straightway before the division bench, because this is flouting at all, if any, is the order of the Honorable Division Bench, not of the learned single bench. And the contempt application has become infructuous, because I am giving to your lordship the dates. What are the dates? When the contempt application was filed? Contempt application was filed on 23rd August 2023. Now, the division bench judgment was delivered by your lordships on 15th April 2024. Even thereafter, it was brought to the notice of the learned single judge that the division bench has modified the order. My lord, the learned judge did not release the matter, and asking us to go before the division bench or asking them to file a contempt application, if any, before your lordships. Can you see the order?
Yes, sir. Mr. Sen, one small clarification.
Yes, my lord.
The direction which we had issued was at page 145, 146.
Yes.
Accordingly, we find no grounds to interfere with the order passed by the learned single bench, except with regard to the direction issued in paragraph 53 of the impugned order, whereby the modified clause 27.2 of CPWD Works Manual has been quashed. And instead of quashing the said modified clause 27.2, we direct the CPWD to appropriately amend their work manual to be in consonance with the notification issued by the Ministry of Steel, Government of India, as done by the notifications referred above. 12 weeks time. Now, pursuant to that, they have passed an office memorandum dated 14th of August 2024, which in your submission does not satisfy the order passed by the division bench.
Right.
There are two things to it. One is, you can always say that there is a violation of the division bench because they did not take into consideration the notification. Second is, for the contempt court to interfere, normally the court advises the party to challenge the subsequent decision. We have done so earlier and drag that matter also to the division bench to be heard. Now, once the order, operative portion of the order has been modified, whether it will tantamount to a contempt, unless and until you are able to convince the division bench that this office memorandum dated 14th of August is to circumvent.
Yes, that is the.
But you could have approached us instead of the single bench because
No,
that direction.
Yes, my lord, what I say, your lordship, my lord, before the appeal was filed, the contempt application was pending.
Then all the more.
My lord, your lordship will kindly see the orders passed in the initial. They have invited the court. It is not that they have taken this point that this court has no jurisdiction.
I have taken the.
I'll show your lordship
the
orders. I will show the orders. My lord, kindly come to the first order at page 100. This is when the contempt application is moved.
But then subsequently,
let me just show your lordship a sequence of the orders and their statement in the affidavit of compliance. Unconditional affidavit saying that I have complied with, they have submitted to the jurisdiction of the court to
No. If you start arguing on those lines, we will grant a stay or the proceedings.
Kindly hear us on
this. No, let us face facts. Let us face facts.
Yes.
The operative portion of the judgment stood modified by the division bench. If the respondents are in breach of the said direction, the writ petitioner ought to have moved the division bench. When admittedly, or what you should have done, you should have filed a supplementary affidavit along with the leave to file before the single bench to challenge the 14th of August order.
Your lordship, this is the challenge is a subsequent aspect, but the question is whether the 14th of August memorandum is actually in compliance of modification in tune with the notification of Ministry of Steel.
That the single bench may not be able to decide because the direction issued by the single bench was modified. So doctrine of merger will apply.
And may I just show your lordship two orders?
You are not going to succeed by dragging these fellows into court. If you want to, advise your client properly. 14th of August, you challenge.
But that does not, kindly see that is a separate right I have, that I have a right to challenge. Even today I will challenge, but where a person, knowing well your lordship's order, has issued this office memorandum, which has nothing to do with your lordship's order to modify clause 27 in tune with the earlier notification. Your lordship will recall.
We need to test the correctness of 14th of August order. And where do you test it? Not before a single bench in a contempt. You can test it before a single bench in a writ petition.
I absolutely
Or you can test it before us in a contempt petition. In all probabilities, we will advise that you please challenge it separately, raise all grounds. We will drag that matter to the division bench. We will hear it along with the contempt.
May I just only say this? I will show your lordship only one order, because such a an argument regarding jurisdiction is being made before your lordship for the first time, not recorded in any order of the single judge, not recorded in their affidavit of compliance. That I am filing the affidavit of compliance without prejudice to my objection.
1977 Supreme Court.
Kindly say,
kindly say, are aware that question of law can be taken at any stage of the proceeding.
This is not
All
a
right,
case
all
of
right.
inherent lapse.
We have
But I
heard
am
the
only
learned.
on one. Kindly see one order first.
No, we are not doing anything. We'll hear you. We have heard the learned additional Solicitor General for the appellant and Mr. Soko Sen, learned advocate, appearing for the respondent contempt applicant. Two issues arise for consideration in this appeal. Firstly, as to whether this appeal is maintainable at the instance of the contemptor under clause 15 of the letters patent, when the order impugned passed by the learned single bench is an order issuing rule of contempt. The second issue is whether the contempt application, which was maintainable before the learned single bench, in the light of the fact that the order passed by the learned single bench was modified by the division bench by judgment dated 15/4/2024 in MAT number 300 of 2024. The modified portion of the order of the by the said full stop by the said judgment, the order and direction issued by the learned single bench was modified, and instead of quashing clause 27.2 of the CPWD works manual, as was done by the learned single bench, the division bench modified the same and directed CPWD to appropriately amend their work manual to be in consonance with the notification issued by the Ministry of Steel, Government of India. It is not in dispute that the contempt application was filed.
May I just intervene once, Lord?
No, we are not doing it. Please hear.
Returnable on 29th. Before that, your lordship kindly hear us out, my lord. That only these two questions are there, as your lordship has pointed out.
No. That is not the issue.
Admittedly, please, sir. Admittedly, the contempt application was filed much before filing of the intra-court appeal. According to the appellant, Office Memorandum dated 14/8/2024 is in terms of the directions issued by the division bench in its judgment dated 15/4/2024. Mr. Sen, learned advocate appearing for the respondent, would vehemently contend that it is not in compliance with the said order, and the learned single bench was fully justified in issuing rule of contempt. Full stop. The other question which we are required to consider is whether
two affidavits were filed, 2 affidavits of compliance.
To consider which are required to be considered and decided is whether in a contempt jurisdiction, whether the court to what extent the court can test the correctness of the office memorandum dated 14/8/2024. Since all these issues involve consideration of legal as well as factual aspect, we are inclined to entertain this appeal, and since the rule is made returnable only on 29th of November 2024, we direct the matter to be listed on 20th November 2024.
Obligement.
If it is not taken now, kindly grant limited
stay. No, kindly. Your lordship will fix the time.
29. If it is not taken up.
In the meantime, the respondents are not entitled to initiate any coercive action against the appellant.
Mr. Sen, only one thing with regard to whether the contempt lies before the single bench or the division bench. Please consider the full bench judgment of our court, passed very recently.
I shall definitely, but I shall only make one submission that is it a case of inherent lack of jurisdiction where the alleged contemner by two affidavits submit unconditionally to the jurisdiction of the learned single
That is not the issue.
Please consider that judgment, Mr. Sen, bring that judgment on the next day.
Yes, I shall. I shall
Blood
definitely
issue,
look
blood
it up.
issue
I shall
is
definitely.
Being
Wait,
presided over
wait.
by Justice Tandon.
I shall definitely.
In this regard, please add one more line before the last line. In this regard, we are also required to take into consideration the recent decision of the larger bench of this court in so-and-so versus so-and-so, reported in so-and-so. Sir, one thing, Mr. Sen.
Yes, sir.
Why are you fighting shy of filing a contempt petition before the division bench?
I shall, may I?
You
I
have
am
not
not.
challenged our order.
No,
You have
no,
not
I
challenged our
accept
judgment.
your lordship's order. I
So
accept
that
your
is number
lordship's order.
one. Number two, by filing an affidavit by the appellant, cannot confer jurisdiction on the court. Very recent, under the Arbitration Conciliation Act, last week, Honorable CJI judgment is there. When you can confer jurisdiction by submitting. All right, he goes and throws up his hand. Does it mean to say that the court will have to rule on its jurisdiction?
Yes, I shall definitely.
I have only,
today the question is just
please allow me to argue.
I have.
Yes, I have right of pre-audience against you under section 23 of the Advocates Act. You are continuously interrupting.
I am only responding to the observation of my lord the Chief Justice.
Kindly appreciate. 15-page judgment delivered by the learned single judge at the time of issuing a rule, and the learned single judge has decided the contempt itself. So kindly grant limited stay till 28. He has been directed to personally appear
on the 29th.
No. That is only on 29th. We have said no coercive action.
He has to appear personally. Personal appearance in terms of the rule.
Your lordship has
kindly grant stay.
All right. Who has to appear?
29th.
My lord, may I say this, my lord? Now, may I have your lordship's leave? I am seeking your lordship's leave to make some submission.
Yes.
Only this thing, my lord. It has fallen from your lordship that why are we shying away from filing a contempt before it is not a question of shying. When a contempt application has been taken up, consider it from this point, my lord. The alleged contemptor initially says, I have complied with, I will file an affidavit. Then when the affidavit of compliance is considered, he makes an argument to justify his compliance. On the basis of the observations which come from the court, he feels that he should file further documents. The learned judge gives him that liberty, and he files a second supplementary affidavit showing compliance. After these two affidavits are filed, then the matter comes up for hearing. He has a full right of hearing. He has exhausted his right of
15-page judgment delivered before issuing the rule.
Exhausted his hearing.
He has decided
then
the contempt.
The learned judge felt that what the division bench directed, you did not comply with that. In a circuitous, indirect method, you have stuck to the earlier notifications which were already there in supersession of the Ministry of Steel notification.
Same issue is being raised.
So therefore, the learned judge felt, no, this is not a compliance of the division bench order, and the rule has been issued. Well, whether the new clause which has been brought is correct or not, discriminatory, harsh, that is a separate cause of action which I have a right to file a writ petition.
Not kindly grant stay till 29th.
Well, kindly do not. Well, because this is only because the higher authority has been called after repeated hearing by a concerned judge. My lord, he cannot say that, my lord, your lordship will fix it on 20th.
We have said no course of action. ASG, we will see on 20th. If suppose for want of time, we are unable to do, we'll see what interim orders have to be granted.
Obliged, my lord. Very much obliged. Very much.
My lord, 28th is a Thursday PIL date.
20.
20.
20th.
Yes.
20.
Obliged.
20.
Yes, sir.
Next.
Item number 26.
What is there?
I think they have not filed the stay application. Not today.
Item number 27.
Yes. When do we beg to appear on behalf of the state budget? Yes, Madam Lordship, I am appearing for the Lordship
Appellant Lordship.
What is this matter, sir?
Challenging the order of refusal of interim order, Lordship, this two analogous appeal 27 and 28 has been filed, Lordship.
What is the interim order you sought for?
Lordship, kindly see the page 66, annexure P8. There is some irregularity caused by the Millard nursing home, which is established under the Clinical Establishment Act. There are irregularities which they have Millard accepted. Kindly see the page 66, annexure P8.
Biomedical waste management rules, color-coded bins, etc.
Now, this order was passed, Lordship,
This is without
any
valid
hearing
fire
given
safety.
to the petitioner, Lordship.
Sir, the thing is, you see the page 66. You don't even have a fire safety certificate. How
Yes,
can
Lordship,
you run that?
that I
They
have,
have
Lordship.
admitted on that second page. On the
Lordship, kindly consider page, Lordship.
Kindly see the reply.
Sir, one thing we can do.
Yes,
You are
sir.
a hospital. You are accountable to the general public. You do one thing. You comply with whatever the deficiencies. You file a compliance report before the authority by this Friday or Monday. We will direct them to consider. You comply with, we will ask them to open.
No problem.
Yes, Lordship. Kindly consider, Lordship, page 37,
All
Lordship.
right. We will dispose of the writ petition itself. These are
may I submit one thing, Lordship?
Yes, sir.
Only one thing, Lordship, that the order which was passed, Lordship, in pursuance of the section 21 of the Transparency Act, without giving any opportunity, because the license and other defect which we undertake, Lordship, that is curable. It is not that that cannot be, Lordship, curable for.
No. Fire safety is not curable, sir. Plastic bins, see, first of all, disposal of biomedical waste.
Yes,
we have heard one matter, sir. We are informing you. We have heard one matter and delivered judgment. Shocking. We don't want to mention the name of the government hospital. Very shocking. You won't believe it. The waste which was dumped is recycled and repacked and sold to private hospitals like your
The
client.
same thing happening here.
We
Same thing happening here.
have the, Lordship, waste management certificate, Lordship.
Kindly have a look.
Certificate, everybody will have certificate.
Right.
Compliance is what is there.
But
The proof of the thing is in eating it. So therefore, you may have all gold medal, etc.
Only thing, Lordship, we are praying an opportunity should be given, Lordship.
Page 74, they have acknowledged everything.
Yes. These intra-court appeals have been filed against orders passed by the learned single bench, refusing to grant any interim order in the writ petition which was filed challenging a closure notice on the appellant hospital issued by the Chief Medical Officer of Health, Paschim Medinipur. On reading of the closure notice, it is seen that the hospital was running without valid. Apart from that, there is an allegation that they have violated the guidelines of biomedical waste management rules, and that the majority of the nursing staff are said to be GNM passed, but they are not registered except to under the WBNC, and it is a violation of manpower norms of the West Bengal clinical establishment within bracket registration, regulation and transparency bracket close rules. Further, it is been stated that one patient ward was seen where male and female patients were admitted and no arrangement for privacy of female patients were found, and this is in violation of the accommodation standards of the West Bengal Clinical Establishment Rules 2017. Therefore, the appellants were directed to stop new patient admission immediately and shift of the IPD patients to other nearby establishment within 2 days. The learned advocate appearing for the appellant would submit that without any opportunity, the closure notice was issued, and the appellant has substantial compliance of all the alleged defects which have been pointed out. The learned government counsel, on the other hand, would submit that the appellants themselves have admitted to the allegation and there is no error in the order passed by the authority. After we have elaborately heard the learned advocates for the parties, and at their request and consent, the writ petitions are disposed of, along with these appeals. Admittedly, the appellant is a healthcare institution, and no lenience can be granted to the appellant from the mandatory compliances which they are required to do in terms of the relevant rules. In any event, if the appellant rectifies the defects pointed out, it will be well open to the authority to conduct an inspection and pass appropriate orders. Therefore, we direct the appellants to comply with all the defects/deficiencies which have been pointed out within a period of 2 weeks from the date of receipt of the server copy of this order. After compliance, they shall submit a compliance report before the authority, and on receipt of the compliance report, the authority shall conduct a surprise inspection of the appellant establishment, note down all the features, and thereafter pass appropriate orders on merits and in accordance with law within a period of 1 week from the date on which the surprise inspection is complete.
Next. To Lordship, my lord. Only one thing, my lord, may I submit before your lordship, my lord, subject to action, my lord. The fire department is saying there is a page 54. If your lordship, I kindly turn to page 54 once for my satisfaction.
What does it say, fire department?
That lack of width space that your lordship find at page 60.
Page 28 lekha ache.
At page 28.
Kindly come to the page 28. The reason which has been narrated by my learned friend.
Page 75. Page 75, my lord, kindly turn to page 75 once. This application was placed before such and such. Observation is inadequate internal driveway, inadequate side space open. The building was there till 2010. My lord,
No, then you can never run the hospital, sir. Sorry.
we have not developed. 2020, they have issued the fire certificate.
Yeah, this is renewable, my lord. This is not sacrosanct.
No further indulgence. Next. Sorry, sir.
Item number 29.
29. 29.
29.
I'll be praying for a short Passover. Madam, I'm led by Mr. Milan Mukherjee, the senior advocate. He is engaged in another court.
So, we will just say not today.
Not today.
Oh, not today. That's all, sir. We'll stop with this. Yes.